Good day and welcome to episode 3 of Stratagem LP's Legal Podcast. This is the podcast where we review case laws and discuss topical legal issues, allowing our audience to stay updated on the law while on the go. Whether you are driving, at home, working out, or relaxing, we've got you covered with insights that help enhance your legal knowledge. In today's episode, we will be discussing a pivotal issue in the Nigerian legal ecosystem, and that is Garnishee proceedings within the context of the current decision of the Supreme Court in the case of Central Bank of Nigeria versus Inalegwu Frankline Ochife and others, hereinafter called CBN versus Ochife. This case focuses on a significant legal battle involving Garnishee proceedings to enforce a judgment for damages of 50 million naira. The first respondent initiated the proceedings to attach funds from the accounts of the second to fourth respondents under the federal government's Treasury Single Account Policy. These accounts were believed to hold funds exceeding the judgment sum, and the goal was to enforce the judgment by seizing these funds. The trial court initially granted a Garnishee order nisi, a temporary attachment instructing the Central Bank of Nigeria to seize funds from these accounts. However, the CBN contested the order and showed cause via an affidavit to show cause, asserting that it did not hold any accounts in the names of the respondents. However, the CBN was not represented in the court on the return date, even though filed an affidavit to show cause. The court of first instance gave judgment in favor of the first respondent by making the decree nisi absolute. The CBN filed an appeal to the Court of Appeal. The Court of Appeal dismissed the appeal, and one of the grounds for dismissal was hinged on a new issue of procedural jurisdiction raised for the first time at the Court of Appeal. Still dissatisfied, the CBN then appealed to the Supreme Court, challenging whether the lower courts had properly evaluated the evidence and applied the law, especially regarding the requirement for the consent of the Attorney General in Garnishee proceedings. The new issue raised at the Court of Appeal, which is central to this review, is the requirement for the consent of the Attorney General of the Federation before Garnishee proceedings can be initiated against any government ministry, department, and agency. At this juncture, it is worthy of note that this appeal was allowed by a majority of 4 justices of the Apex Court, while Ogunwumiju GSC allowed it in part and disagreed with the majority judgment on some vital positions of law. Being a decision of the Supreme Court, the judgment of Ogunwumiju, even though a minority, is vital and binds lower courts. Thus, we shall review the majority decisions first and thereafter the judgment of Ogunwumiju GSC. The Supreme Court, in the leading judgment of Apiru GSC Suomotu, raised the issue of whether the Court of Appeal can entertain the issue of procedural jurisdiction, such as the failure to obtain the consent of the Attorney General for the first time in the Court of Appeal. The law lord held that Suomotu means an issue raised by the court on its own motion. When it comes to jurisdiction, an appellate court can raise and determine the matter without hearing from the parties, as jurisdiction is fundamental. He held further that jurisdiction is a broad term, but it primarily consists of 2 subsets, procedural and substantive jurisdiction. Procedural jurisdiction refers to compliance with certain conditions before a case is heard, while substantive jurisdiction is the legal authority of the court to decide a matter. Procedural defects must be raised early or they may be considered waived. A party cannot raise the issue of failing to obtain the Attorney General's consent for Garnishee proceedings for the first time on appeal. Thus, the Court of Appeal lacks the jurisdiction to entertain the issue of failure to obtain the consent of the Attorney General, and since the Court of Appeal lacks the jurisdiction to treat the issue, its decision on it is void, and the Supreme Court cannot entertain an appeal on an issue decided on by the Court of Appeal without jurisdiction. Now to the majority decision on Garnishee proceedings. Garnishee proceedings are a legal method for enforcing a money judgment by attaching debt owed to the judgment debtor by a third party, known as the Garnishee. The process is governed by the Sheriffs and Civil Process Act and consists of an order nisi and, if necessary, an order absolute. A Garnishee disputing liability must provide specific facts in an affidavit. The Garnishee may be discharged if the judgment creditor does not contest the denial. If there is a real dispute, the court may conduct further inquiries. Courts must evaluate evidence in Garnishee proceedings objectively. Thus, the judgment creditor must provide verifiable evidence showing that the judgment debtor's funds are in the Garnishee's possession before the court will grant an order absolute, and the court must avoid personal biases and assess the credibility of the evidence. The majority judgment allowed the appeal on the ground inter alia that the second to fourth respondents, who are the IGP, the Commissioner of Police (FCT), OC Intelligence Response Team, and SARS, are not ministries, departments, and agencies of the government, and as such do not have any money in the TSA to be garnished from the CBN. Now, to the crucial points of law from which Ogunwumiju GSC departed from the leading judgment. The law lord Ogunwumiju GSC commenced his judgment with these words: I have had the privilege of hitherto reading the lead judgment of my learned brother Habib Adewale Abiru GSC. I agree that the appeal be allowed in part, and I wish to depart from His Lordship's view on certain preliminary points of law in this case. She held that the Sheriffs and Civil Process Act is a substantive legislation, and as such, the jurisdiction issue pursuant to Section 84 that was raised is that of substantive jurisdiction, in contradistinction to the majority decision that held that it was an issue of procedural jurisdiction that cannot be raised for the first time on appeal. She then painstakingly traced the historical genealogy of the requirement for the consent of the Attorney General. She held that under the 1979 Constitution, Section 251, subsection 4, required that the Attorney General of the Federation's consent be a condition precedent to Garnishee proceedings against government entities. I hereby reproduce Section 2514 of the 1979 Constitution as amended by the Constitution Suspension and Modification Decree number 107 of 1993. I quote, notwithstanding the provisions of this section, no person shall endorse a judgment against a ministry or extra-ministerial departments without the fiat of the Attorney General of the Federation or the Attorney General of a state, whether or not he was, in either case, a party to the proceedings. As read supra, this important safeguard was introduced during the military government era, particularly through Decree 107, which amended Section 251 of the 1979 Constitution. The AGF's consent was necessary to ensure that due process was followed in matters involving government funds, which are often more complex and sensitive than the private matters. However, when the 1999 Constitution replaced the 1979 Constitution, it removed subsection 4 from section 287 of the 1999 Constitution, which mirrors section 251 of the 1979 Constitution. Therefore, the Attorney General of the Federation's consent requirement for Garnishee proceedings against government entities no longer had any constitutional foundation and thus was effectively eliminated. This shift reflected a broader move towards improving access to justice and removing constraints seen as remnants of military rule. The Supreme Court further held through Ogunwumiju JSC that Garnishee proceedings against government entities no longer require the AGF's consent under the 1999 Constitution. The court's judgment also tackled a significant conflict between Section 84 of the Sheriffs and Civil Process Act and various provisions of the 1999 Constitution as amended. Section 84 of the Sheriffs and Civil Process Act made obtaining the consent of the AGF a condition precedent before instituting Garnishee proceedings. The central question here was whether Section 84 of the Sheriffs and Civil Process Act is inconsistent with the 1999 Constitution, particularly Sections 1, 3, 6, and Section 287. Which mandate the enforcement of judicial decisions. The Supreme Court per Ogunwumiju JSC held that since the 1999 Constitution has removed subsection 4 from section 287, section 84 of the Sheriffs and Civil Process Act becomes grossly inconsistent with the said sections 1, section 3, section 6, and section 287 of the 1999 Constitution as amended, and thus unconstitutional. The court found that granting the AGF discretionary power over the enforcement of court judgments undermines the judiciary's independence and interferes with the separation of powers. By allowing the AGF to control the enforcement of judicial decisions, the Sheriffs and Civil Process Act violated Section 287 of the 1999 Constitution as amended, which requires all authorities and persons to enforce court decisions without delay or obstruction. Justice Ogunwumiju JSC, while departing from the majority decision on this point of law, strongly disapproved of Section 84. He held that Section 84 of the Sheriff and Civil Process Act placed an unelected executive official in a position to influence the enforcement of judicial decisions, which breached the separation of powers principle enshrined in the Constitution. According to the justice, allowing the AGF to withhold consent for Garnishee proceedings was an unconstitutional impediment to justice and a direct contradiction to the duty imposed on all authorities and persons to enforce judicial decisions. The judgment stresses that the judiciary must remain independent and capable of enforcing its decisions without interference from the executive. Moreover, the court pointed out that the AGF's control could result in embarrassing situations where a valid court judgment involving government entities will be subject to the whims of a single executive official. This, the court held, will be detrimental to the independence and the credibility of the judiciary and the international reputation of Nigeria's legal system. The judgment re-echoed that Unlike other statutes that impose procedural conditions within the exclusive control of the litigant, Section 84 gave the AGF excessive power to decide whether or not to enforce a court judgment. This distinction was highlighted as a significant factor in the court's judgment. In conclusion, this judgment is a milestone in judicial independence. The case of CBN versus Ochife and others marks a critical turning point in the legal landscape of Garnishee proceedings in Nigeria and judicial independence in general. By affirming that the AGF's consent is no longer required under the 1999 Constitution, the Supreme Court has taken an important step in ensuring that the judiciary retains its independence and that court decisions are enforced without unnecessary hindrances. This judgment serves as a reminder that in a democracy, judicial decisions must be respected and enforced promptly, and no executive body should have the power to impede or delay this process. The decision also paves the way for more efficient enforcement of judgments, ensuring that justice is accessible and timely, especially in cases involving government entities. The case is a testament to Nigeria's legal system's ongoing evolution and commitment to upholding constitutional principles that safeguard judicial independence and access to justice for all. Thank you for listening to this episode of Stratagem LP's Legal Podcast. I remain your principal host, E.B. Ochuma Esquire. Join us next time as we continue to explore the legal issues that shape our society. Until then, stay informed, stay empowered, and keep learning.